Do you have any idea of character evidence? Have you done that? We did talk about character evidence. Okay, that can you see the board? Yeah. I don't see enough light here. Maybe because of this. Anyways, character evidence. In short, in summary, character evidence can be divided into two categories, and they are good character, bad character. Okay. From another perspective, character evidence can be divided into two categories. One is defendant's good defendant's character. Other one is non-defendant's character. Okay. Now, most of the focus, 90% of the focus in character evidence is taken by this defendant's character, because most of the time prosecution and prosecution witnesses are concerned with defendant's character, mostly defendant's bad character. However, defense witnesses sometimes and defense lawyers sometimes are concerned with the defendant's good character. Defendant is in focus. But then again, apart from the defendant, in a criminal proceeding, non-defendant's character can also be at issue sometimes. Okay, when can that happen, and who is the non-defendant? Whose character may be relevant? Most importantly, it's the witness, and sometimes the deceased victim. Okay, the witness's character. Now, so basically, what happens is in a criminal proceeding, apart from the defendant, there is another person whose character may be at stake, whose character parties may be interested to bring in, and he is the witness. 90% of the cases, it will be the witness. Sometimes, on the 10% of the cases, it may be so that apart from the defendant, someone else's character parties will be interested in, and that would be the deceased victim. Now, you may ask, why the deceased victim, and why not the victim who is alive? If the victim is alive, 99% possibility that he will be a witness in the proceeding. You follow? Because if I'm the victim of a particular criminal action or criminal offense, I am most certain to be called in as a prosecution witness. Okay, so the focus is on non-defendant means witnesses. Okay, good. So character can be good, can be bad. Character can be relevant of defendant's character, non-defendant's character. Most importantly, witnesses' like. Now coming to the point, what is the effect of admission of character evidence in a criminal proceeding? The effect of admitting a character evidence is twofold. One, credibility. The other, propensity. Now, what is the credibility effect? Can anyone try? Can you try to talk about credibility? Do you know what is credibility?
In very simple terms, if the witness has is perceived to have a good character, then they are likely to be more credible.
Yeah. What is credibility?
Strength of your.
What is credibility?
Respectability.
Respectability. Okay. It's more like credibility means is more likely to be speaking the truth. Yeah. Whether or not he is worthy of belief, trustworthy, believability of a witness's statement. How high is the believability? The higher the believability of the witness, the higher the credibility of that witness. The lower the believability, the lower the credibility. Okay, so that is there. Hello? Okay. Right. So, credibility. Right. Credibility basically means believability. whether or not a person is worthy of belief, whether or not a person is to be trusted on belief. Now, it has character evidence has effect on the credibility of the person whose character has been put in. How? Say, for example, a very common point would be this: that a person's good character, a person with good character, is more likely to be more credible. A person with bad character is less likely to be more credible. You follow what I'm saying? That is the effect on the jury of a person's character evidence being admitted in the proceeding. Okay, so if a person's character evidence, whether he's a defendant or whether he's a non-defendant, irrespective of that, if a person's character has been put in the proceeding for the jury to consider, then the jury will have twofold effect. One, it may have a credibility effect. The other one is a propensity effect. Let me talk about the credibility first. Credibility effect depends on whether it's a good character evidence or whether it's a bad character evidence. Both the character evidences have effect on the credibility, right? What is it? Good character evidence. A person with good character is more likely to be believable. That is the good effect, credibility effect. A person with bad character is less likely to be believable. That is the credibility effect. Now, what about propensity? What do you mean by propensity? Propensity, anyone? No? Propensity means likelihood of doing something or committing an offense. Likelihood of doing something or committing an offense. It's like if I have a propensity towards something, that is, it's like you can somehow relate propensity with a blueprint or a tendency, if you know what I mean. Tendency. Every person has a blueprint. For example, I am likely to do a particular thing in a particular way, and I'm not likely to do it in another way, in another person's way. I am unique in my own way, right? So are you, and so is anyone else. So that means I have a particular blueprint of doing things in a particular way. No matter how many times I may do it, I'm likely to do it in that way. You know what I mean? So for example, if I am to react to a situation, I am likely to react to a situation in a particular way as I have been reacting in those particular situations in the past. I am less likely to react in a different way as I have been reacting to the similar situations in the past. You follow what I'm saying? Now that is the propensity effect, or one may say the tendency effect. Now what is that? How is it relevant? Now again, propensity means whether or not this particular person is more likely to have done it. Whether or not the particular person is has a higher propensity to do it, has a higher tendency to do it. Now, how's the effect? How's the character effect? So, for example, a person with good character is less likely to have committed a particular crime. Now, propensity relates to defendants only. Propensity does not necessarily relate to non-defendant's character. You follow what I'm saying? Non-defendant's character has only one effect, and that is the credibility effect. Why? Because the witness, we are not concerned with whether or not the witness has actually done it. We are concerned, the jury should be concerned as to whether or not the witness is more likely to be believed on his oath. Whereas for a defendant, the jury may have both the effects. Why? Depends on whether the defendant is testifying. If the defendant is also testifying, as you know, every defendant has a right of silence. He's not bound to testify. He can testify if he so wishes. But then whether or not he decides to testify is entirely his privilege, and it is entirely his own choice. Now, coming back to the point, whether or not character evidence will have both the effect on as far as a defendant's character is concerned. In other words, whether or not there will be credibility effect as well as propensity effect on a defendant's character issue. Answer? Well, the answer depends. If the defendant decides to testify, then his background information, i.e. his character evidence, will have both the effects. Effect as to credibility, effect as to propensity. Are you with me? If the defendant testifies, you're there? You're there? No, you're not here. Lost. Okay. The defendant has a right of silence, right? As far as English law is concerned. Defendant may wish to testify, may wish not to testify. You can take that inference that the defense to your defendant. You can do whatever you want to. That's a different story altogether. But I have a right of silence. You cannot force me to talk, can you? No. The defendant cannot be forced to talk. The defendant cannot be compelled to give evidence on behalf of the prosecution or on that matter, because he has a right of silence. So he's not bound to speak. So what if the defendant does not testify? Or what if the defendant does not rely on any evidence or any statement that he has stated? So there is nothing to rely on defendant's statement. There is nothing to talk about defendant's credibility as far as that particular file is concerned. Are you with me? Therefore, if the defendant does not testify, the character of the defendant will not have the credibility effect. Why? Because for the jury, there is nothing to consider whether or not to believe the defendant, because there is nothing to believe. He has not said anything. Are you with me? Are you with me? So, general rule আমরা টিকটকে যেটা দেখেছিলাম যে একটা credibility effect থাকে একটা ক্যারেক্টারে। So for example, শাফায়েত যদি একটা ভালো চরিত্রের মানুষ হয়, তাহলে শাফায়েত is more likely to be believed. Is more likely to be believable. He's a person of good standing in the society. He holds a good position in the society, so he is more likely to be believable when he takes oath and says something. আমি যদি বলি আমি সার্টিফাই করছি যে এটা ভালো বা এটা দেখেছি এটা হয়নি এটা হয়েছে এটা ইত্যাদি ইত্যাদি, if I'm a person of good character, that good character information or that good character evidence is likely to have an effect on my overall credibility as a witness. Are you with me? However, on the contrary, যদি আমি অনেক দুই চারটা আমার কনভিকশন থাকে তাইলে পরে আমি যা বলি ওটার উপর একটা ইফেক্ট থাকবে। But then again, credibility effect তখনই থাকে যখন আমি কিছু বলি, when I have something to talk about or I give evidence or I rely on certain statements, then the question of credibility may arise. However, as far as the defendant's character is concerned, he may or he may not testify, but surely his propensity to have committed the offense will surely be an issue in the trial. I see. Clear? What is propensity? As I said, a person of good character is less likely to have committed the offense. A person of bad character is more likely to have committed the offense. That's the effect. Good. Now, then we did that's the basic discussion on character. Now let's move into more detailed discussion. First of all, let's talk about good character. Now, as an evidence of good character, only evidence of general reputation may be put in. Now, what is general reputation? General reputation as opposed to any particular reference to a particular fact. More like a general reputation. Okay. Good character evidence. Whose good character is likely to be put in? Now, in general, this has been a common practice. Whenever there is an accused, for example, if there is a proceeding against you, I am likely to take the plea that not guilty, right? If I take a guilty plea, there is no point of talking about all the evidence. There is no point of holding a trial. There will not be a trial. If I mean guilty plea kori, there will be no trial, right? So there is no point of talking about evidence. There is no point of about this witness, that witness, evidence, this, that, no, nothing, because there won't be any trial once I plead guilty. Once I plead not guilty, then there will be a trial. So the prosecution responsibility will be to prove me guilty, right? Good. So whenever they will try to prove my guilt, but on the contrary, I will say I'm not guilty. So it's likely, and it has been a common practice, whenever there is a person of good standing, he is likely to bring in evidence, a good character witness, for example. Who's a good character witness? A good character witness can be a person of good standing in the society who will certify that he's good. He appears to be a person of good character, of good moral values, this and that, blah blah blah. I've known him for such and such years. He has been a good, responsible person, responsible citizen of the society. Somewhat like this. Not specific mention of specific incidents. The Shafayat is a good person because Shafayat did this to me last night, or Shafayat did this to me last year. No, that is not acceptable. But a general reputation as opposed to a specific mention of a specific incident or a specific event. Okay, that is acceptable, or that is admissible. So general reputation and all. But in good character, there is a very, very important thing that you need to know, that is R versus Y, which gave Y direction. Now, R versus Y, there was a direction given, which is known as the good character direction, which also got known as Y direction from the name of the case. And that is what you need to consider and you need to really, really hit in your examination. Now, what is Y direction? Y direction is this. If any particular accused provides a good character evidence in the form of a good character witness or any other source, okay? So he asserts that he's a person of good character, and he also says that he has not been involved in any sort of criminal activity. Unlike a common statement, that this person has not taken part in any act subversive of the against the state, or he has not done anything. He's not involved in any kind of criminal prosecution or criminal proceeding, blah blah blah. তোমরা যখন অ্যাপ্লাই করেছো তোমাদের লিগ্যাল জেনারেল অ্যাপ্লিকেশনে তোমরা এই ধরনের ক্যারেক্টার সার্টিফিকেট পেয়েছো ঠিক জেনারেল কথাবার্তা যে না ও ভালো হয়েছে so far as to the best of my knowledge he is not involved in any activity against the state or law, and there is nothing proceeding, nothing pending, no criminal proceedings pending before him. এই যে একটা কথা, these are good character evidence, good character witnesses. Point key by দেখি বলা হচ্ছে বাইতে বলা হচ্ছে যে if a person provides good character witness, provides good character evidence, then he is entitled to a direction, which is known as good character direction, also known as bi-direction because of the name of the case. That is super duper important, because if any particular defendant has provided good character evidence, but the judge somehow failed or forgot to give a bi-direction, then that can be a successful ground for appeal and questioning of the conviction. So that shows how important it is. Now, what is the bi-direction? Again, there is no specific terminology given for giving the bi-direction. However, a guideline has been provided. What is the guideline? The bi-direction must consist of two limits. One, the propensity limit. The other, the credibility limit. Okay, two limbs. The bi-direction generally consists of two limbs. One, the propensity limb. The other one is the credibility limb. Now, what is the propensity limb? Let me talk about it. The propensity limb is somewhat like this. Judge will give the jury a direction in somewhat these terms. Not exactly these terms. He can choose his own terms, but somewhat these terms. That's the guideline. What is it? Members of the jury, this person appears to be a person of good character. He has already provided good character witnesses. Before you have had the opportunity to consider or hear him. It is my duty to remind you that a person of good character, propensity limit, a person of good character is less likely to have committed the offense with which he has been charged. I repeat, careful, members of the jury, you have heard the witnesses, you've done this. Once the witnesses are closed, right? The judge gives a direction to the jury. Members of the jury, you have heard you heard that this defense has provided a good character witness or good character evidence. It is my duty to remind you that a person of good character is less likely to have committed the offense with which he has been charged. However, whether or not he is guilty of the current charge, it is for you to decide on the basis of facts and circumstances and information provided before you through the witness's testimony and other evidence. It's like a reminder, it's like a flagging. No, he is a person of good character, so do consider the fact that he is so far clean. If he gets a conviction, he is no longer clean. But before you give him the conviction, do be mindful of the fact that he has provided a good character evidence, and therefore is considered to be a person of good character so far. And it is my duty to remind you that a person of good character is less likely to have committed the offense with which he has been charged. However, whether or not he has committed the offense is for you to decide based on facts and circumstances of this particular case. So এটার অর্থ হচ্ছে যে jury has a final say. The judge কি করবে? Judge সাহেব জুরিকে একটা রিমাইন্ডার দিবে। যে রিমাইন্ডার, jury রিমাইন্ডার। এটা তাকে দিতে হবে ম্যান্ডেটরি। যদি না দেয়, what if the jury just forgets it? And হয় কি জানো? Generally যেটা হয়, for any accused, it's an allegation, right? The moment a criminal allegation has been raised against me, I'm not guilty. But tendency is always against me. The media, the jury, the people, anyone, whoever is seeing me has a negative view about me. But that's unfair, right? I have not yet been proven to have committed the offense. But that's there. Therefore, even if I've provided a good character witness, it is likely that the jury somehow may overlook it, because they may be so very overwhelmed with all the evidence against me, they may actually forget or somehow oversee, the good character part. So the judge's responsibility is, as per R versus Y, to give a reminder. This is called good character direction, right? Propensity limit. The credibility limit. Again, it has another limit. It says, members of the jury, it appears that this person is a person of good character. Let me remind you that a person of good character is more likely to be believable or not, or more likely to be believable, is more credible as a witness, or something like that. Something along the lines. Okay? Members of the jury, he appears to be a person of good character. Let me remind you, a person of good character is more likely to be believable than not. However, whether or not you believe his story is entirely for you to decide. My responsibility was to inform you or to kind of warn you of the possibility. That's the credibility limit of the good character. So what is it then? The person of good character, if he has provided good character evidence either by witnesses or somehow with some sorts, if he has provided good character evidence before the court, it is the responsibility of the court to give the good character direction, which consists of two limits: credibility limit and propensity limit. Credibility limit more likely to be believable, propensity less likely to have committed the offense because it was of good character so far. However, whether or not he's committed, whether or not you are likely to believe him, is entirely for you to decide. Question: do you think in all the cases both the limbs of the direction should be given? Irrespective of the cases, irrespective of factual circumstances, both the limbs of the direction should be given to all cases, do you think? Yes, no? If this you're not here, tell me, you should be.
Credibility, not necessary.
Why not? Why not? Credibility, why not necessary? Tell me.
Propensity has to be there.
Yeah. Credibility, why not? Okay. Credibility, yeah, you're right. You're right on the point that in any case, propensity must be given. Why? Because the propensity of the defendant is always at stake. Because there is a proceeding against me, right? You are continuing a proceeding against me. So my propensity to have committed the offense with which I have been charged is always an issue. The jury are always likely to be considering that. That is exactly what they're doing, they're expected to do, right? So the judge must give the propensity limit whenever I have a good character. But the judge must give the propensity limit of the by direction. However, the credibility limit, which are answered down to credibility limit may only be necessary if the defendant testifies. If the defendant testifies, what if the defendant does not testify or does not rely on any statement? Then there is no need for the credibility limit. Actual question. Acha, how can you follow the testify to amra bujhi, right? He gives evidence. He takes oath. He gives evidence. Again, the defendant has a choice not to. He has a right not to, but he can actually give if he so wishes to. Okay. And it's expected. It's actually suggested that the defendant should not testify. Why? Because once you testify, you are then subject to cross-examination. If you don't testify, cross-examination is out of the way. No one can cross you. But if you testify, then you are subject to cross. And when you are cross, we have done that chapter, you know. When you are cross, it is likely that on some questions you may be uncomfortable, and and by being uncomfortable, by giving a kind of a negative body language, you kind of give away the impulse, the kind of some sort of an implication to the jury through which they can come to a conclusion against you. So it's better not to testify unless you actually that's there. But then again, if you say, for example, say I don't testify, I'm the accused. I decide not to testify, but I did, because we are at trial. I did take my plea, and my plea was a plea of not guilty. Are you with me? So if I have taken a plea of not guilty, question, have I made a statement? Say in the proceeding, I decide not to testify. Charges of not guilty, trial legacy, trial, I will not testify. Prosecution brought 1, 2, 3, 4, 5 witnesses. I brought my good character witness or good character evidence was given on behalf of me. Is a person of good reputation, blah blah blah. Good. So I am entitled to good character correction as per by. Fine, propensity lien has been given. Question: I am not testifying, therefore credibility is not necessary because there is nothing for me. There is nothing for me to be to rely or nothing to believe. I have not said anything. Question: but I've already taken a plea of not guilty. Is it not saying anything? Is it not saying something? Is it not a statement? Yes. So should the jury not consider? Should the jury not consider that I've made a statement that I'm not guilty? So whether or not they should believe me or whether or not they should not believe me. So is that not an issue? What's your name?
Shopping.
Shopping. Yeah, shopping. Tell me.
If the defendant says that he's not guilty, and if he has provided sufficient good character evidence,
so question is, yeah, I have taken a plea of not guilty. Hence the trial. If I had said guilty, there wouldn't be no trial, right? So I have taken a plea of not guilty. That took us to the trial. There is a trial, but in the trial I decided not to give evidence. So I decided not to testify. Question: do I still need to get the credibility limit of the right direction? That's the question. Because I've taken a plea of not guilty. Yes, Imtiaz.
So if we do take this into account, the fact that he pleaded not guilty, then this would defeat the purpose of testimony.
Yeah.
Because then if there will be no need for someone to testify, because
now it's up to him whether he decides to testify or not. But my question is, when I take a plea of not guilty, is it my statement? Is there something to believe here? Or in other words, is my credibility is in an issue here? Because I've taken a plea of not guilty. Am I saying, when I say I'm not guilty, am I actually making a statement?
yes, sir.
And am I actually asserting that I have not done it?
I'm not guilty means I have not done it.
Do you think so?
there is a presumption of innocence, right?
No. Oh, please get this. When I say I am not guilty, am I saying I did not do it? Oh, this question. Okay, answer is Jani, but yeah, good one. There is something to think about. When the accused says not guilty, he does not say that I have not done it. He merely says, I do not admit to have done it. There's a difference. আমি বলছি শব্দের তুমি এই গ্লাসটি ভেঙেছো বা তুমি এই এসিটি ভেঙেছো, you have caused no damage of this air conditioner. তুমি বললা I don't admit. Now when you say you don't admit, but when you say I'm come on, what's your plea, guilty or not guilty? You say not guilty. When you say not guilty, are you suggesting that you have not done it? No. You are suggesting that you don't admit you have done it. Are you with me? And that's your right. Because when I'm the prosecution, because in criminal proceeding, prosecution is alleging that you have done blah blah blah. It is the responsibility, the burden lies on the prosecution to prove the allegation. And there's a presumption of innocence. And you have a choice, either to plead guilty. If you plead guilty, you're actually making their life easier. You are not bound to plead guilty, even if you've done it. You can, if you so wish to. But the fact remains that it is the responsibility of the defendant to kind of prove that you are guilty as charged. Are you with me? So you just saying not guilty is not making a statement as such, and there is nothing to believe on the plea. Unless and until you categorically make a statement, in other words, you appear as a witness, you make out a case, then comes the question of whether or not the jury should believe your case. When you say not guilty, you actually don't have a case. You did not say, you did not give up a case. You merely say, I don't admit. You prove. So that means the prosecution still has to prove it. But you did not say anything. You just say you don't admit. And therefore, there is nothing for the jury to believe in what you say. The jury should only know that you did not admit it. Clear? Hence, if the defendant or the accused does not testify, there is no need for credibility determination. Clear? Clear? So So mere plea does not do it. Okay, good. We will talk about a difficult situation, and the difficult situation is what about co-accused? Suppose we have co-defendants, and we know what co-defendants are, right? When two people are tried together, immediately for more than one. So suppose there is Shafat and there is Imtiaz. We both are being tried together for a charge of doing something criminal damage. I have previous convictions. I have 2 previous convictions. Okay, so I'm a listed criminal. You are not. You're fresh. And you have provided. You already have a clean record. You have provided a good character. Question: because both of us are now being tried together, D1, D2. D2 has good character evidence. D1 doesn't. Question: whether in this proceeding the judge should give the by direction, because the judge cannot give by direction in general, saying members of the jury, the accused persons appear to be persons of good character, blah 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 blah, blah, that they are less likely to commit the crime, because Shafat has 2 previous convictions. Imtiaz has none, and Imtiaz has provided good character of witness. Shafat didn't. So if the judge says that members of the jury, Shafat, we can see there are 2 witnesses and there are 2 accused. Accused number 1 has had some previous convictions. Accused number 2 did not have any previous conviction and also provided a good character witness. So he appears to be a person of good character. Let me remind you that accused number 2 is less likely to have committed the offense, is more likely to be believable, whereas accused number 1 is not. Do you think he should say that? Now, if he says that, it may help Imtiaz, no doubt, but it is surely going to affect Shafat in a negative way. And in a criminal proceeding, you cannot prejudice the accused, right? You cannot give in that information or negative information to the jury. However, good character direction is positive information. That's an exception. But the problem is when in a co-defendant situation where there are multiple accused, one has good character evidence, the other does not. How does the judge deal with it? Does he actually give a good character direction? Does he not give a good character direction? If he does not give a good character direction, that would be a violation of R versus Y, because Y said that whoever produces good character evidence must be given a good character direction, right? Now, so Imtiaz is entitled to good character direction, but the problem is he's not alone. He's the Shafat as well. So when he has previous convictions, he's a person of bad character. The judge, if he wants to speak about Shafat and Imtiaz both, then the problem is Shafat will be prejudiced. Whether the judge should do it, how will he do it? That's a difficult situation. Answer is, the judge will still have to give a good character direction. However, it is suggested that the judge should not mention anything about the person who does not have good character. He should only mention members of the jury. It appears that Imtiaz has provided a good character witness. Therefore, it is my duty to remind you that a person of good character is less likely to have committed the offense, is more likely to be believable. However, it is for you to decide ultimately whether he is guilty of this charge or whether he is believable or not.
Can the jury ask the judge?
No. The judge will say, the judge will only reply, I don't have any such information. Oh, okay. But the judge should not lead the jury that Shafat is a person of bad character. Yes, it will do the damage. I know. But then, if you assemble, I mean, just to it kind of gives a wrong impression to shopping. Third party will say, oh my God, something true. But then, the person of good character is entitled to good character direction. Just because he's been co-tried, he's been tried jointly with another person who is person of bad character, does not automatically mean that the person of good character should not get his direction. But also, the judge should also make sure that he does not give out negative information about the other person. But he's just keep quiet about the other person, somehow ignore this and talk about it. Got it?
So in this case, there is no violation of Article 6.
No, because I did not say bad things about you. I could not give you a good character direction because you're not a person of good character, or you did not have a good character witness. So I'm not bound to give you a good character direction anyway. But just because you are not a person of good character, but your friend is, just because you both are being tried together, I should not deprive the friend of the good character direction which he's entitled to. Got it? Good. We move on. Next will be bad character. Okay, anyone has any question on good character? That was a pretty quick good character. Good character খুবই গুরুত্বপূর্ণ এই জন্য যে তোমার any person of good character যদি কোনো এভিডেন্স থাকে good character witnesses আছে আসে তাহলে ম্যান্ডেটরি ভায়োলেশন দিতে হবে ভায়োলেশন দিলে দেখা করে দিতে হবে কোনটা কখনো yes
good character evidences কি হতে পারে example
কি বললাম general reputation যে he appears to be a person of good social standing he appears to be a good philanthropic person that's okay একজন he appears I have known মানে এটা একজন সমাজের যেমন তোমরা লিখেছেন অ্যাপ্লিকেশনের সময় দেখো তোমরা জাজের কাছে নিছো কোনো একটা সমাজের দুটো রেফারেন্সেস না তোমরা একটা জাজের কাছে নিছো একটা কোন একটা টিচারের কাছ থেকে বা কোনো একটা কাছ থেকে লয়ারের কাছ থেকে নিছো that's reference that is a good character reference right ওরকম কোন একজন স্বনামধন্য তার কাছ থেকে নিতে হবে বাট সেগুলো স্পেসিফিক মেনশন করতে পারবে না it is not a specific information যে why do I think you are good because আমি যদি বলি যে ও আমাকে রাতে খাওয়াইছে বা ও ওদেরকে আমাকে নিয়ে এসে আমার ছেলেকে নিয়ে স্কুলে দিয়ে আসছে বা আমার উপকার হয়েছে বা আমার মেয়েকে কি বলে ওই ফান ফেয়ার থেকে ঘুরে নিয়ে আসছে এই জন্য সে অনেক ভালো মানুষ আমি যদি এরকম একটা স্টেটমেন্ট দিই দ্যাট ইজ নট অ্যাকসেপ্টেবল okay because that is why it is entirely personal matter that does not give us that does not give the jury an idea of who what type of person you are in general so it's your general reputation remember that as opposed to a specific information or specific mention of a specific incident. To me, it's too personal. It's too personal, and you know, you may be a bad person, but you may be good to a particular person in a particular instance. But you know, if you are a bad person, then you are less likely to have a general reputation of good reputation, so to speak. বুঝতে পারছেন কথা? আমি প্রত্যেক মানুষ যদি খারাপ ভালো থাকে, আমি তোমার সাথে ভালো কথা বলবো খারাপ কথা বলবো। তুমি যদি সমাজের ওভারঅল রেপুটেশন নিয়ে জিজ্ঞেস করো, তুমি আমাকে অনেকদিন ধরে চিনো, তুমি যদি বলো ভাই বলো সবাই তুমি হয়তো একটা জেনারেল কথা আমার সবাই ভালো কারণ উনি আমাকে অমুক তারিখে টাস্কিং করেছে then it's not acceptable but he may be a bad person but he may have treated you and asked you last time that does not make Shafat a person of good character but না ওনাকে যখন জানি আমি ওকে 7 বছর 5 বছর ধরে চিনি 3 বছর ধরে চিনি এই জিনিস হয়েছে ওর সম্বন্ধে যা শুনছি is a person of good character with good moral values but বলে যে he tries to help people is okay but he has helped me on that no general reputation he tries to help people or he helps people when he wants or when he can but as far as he's a person of good we haven't heard anything bad about him he's a good law-abiding citizen okay a person of good social standing something like that but not that he's a member of Club he's that he's done this he's done that no general not specific
okay sir yes if it so happens that the defendant has been previously accused and then been acquitted is that bad character evidence
we'll talk about this I've been accused of something bad character for কথা বলি bad character এখন বলতে actually জিনিস বাকি আছে বলা সেটা একটু বলে দিচ্ছি rehabilitation of offenders act এটা নিয়ে একটু কথা বলি সেটা হচ্ছে তোমার rehabilitation of the offenders act 1974 this talks about spent convictions in short let me just say a few words on this spent conviction একটা কথা আছে সেটা কি জিনিস যদি দেখা যায় যে একটা কোনো accused অতীতে কোনো এক সময় কোনো একটি অফেন্সে কনভিক্টেড হয়েছিল এবং সেই অফেন্সের যে নির্ধারিত সাজা যে সেন্টেন্স সেটা সে খেটেছে whatever say 3 months 3 years 2 years এর একটা কনভিকশন দিয়েছে আমি কোনো একটা মারামারি করছিলাম সেকশন 47 এ ওয়েতে আমাকে কনভিকশন দিয়েছিল 2 বছর 2.5 বছরের সাজা হয়েছিল আমি সেটা খেটেছি যখন আমার বয়স ছিল 18 বা 20 আমি ভিতরে গেলাম 22 বছর বা 23 বছর বয়সে আমি বেরিয়ে আসলাম right and then after that I became a different person and I was so far I was clean I was 23 when I was 23 I got out and I maintained a clean life and then now I am say 43 so it's been 20 years right and now I have been charged with some 47 20 yeah offense আমাকে এখন চার্জ করা আছে 20 বছর পরে ঠিক আছে এই অফেন্সের এখন প্রসিডিউর চলছে প্রসিডিং চলছে আমি নট ডিটেইল করছি now coming to the point whether or not I'm entitled to a good character direction that's the question in other words whether or not I should be considered to be a person of good character in other words whether my previous conviction I did have a previous conviction didn't I yes that was like 23 years back and I kind kind of served it. I got out 20 years back. For the last 20 years, I've been clean. And now again, I have an allegation against me, now for which I'm now being prosecuted. I'm now being proceeded, right? Question: am I to be considered? Do I have a previous conviction? I do. But then whether that previous conviction should be considered as a bad character. Now that is this act. We have a Registration of Offenders Act 1974. That tells us about this, that if a particular conviction has been served, if a particular conviction has been served, and after having served it, if the defendant has had a kind of a clean time. Now, how long, that has not been defined. The longer, the better, depending upon the seriousness of the conviction. So, for example, had that been a petty offense, I would say 4 or 5 years would be a good enough gap. Had that been a pretty serious offense, I would say maybe 50, 20 years should be good. But what is good time is for the judge to consider. So the point is this: if the judge feels that this person has already served a particular conviction previously, and after serving the conviction, the sentence of the conviction, he has so far maintained a clean record, and it has been considerable time. How long is considerable time is for the judge to consider. And it has been a considerable time. The less serious the conviction, the less the time period required. The more serious the conviction, the more the time period required for you to be considered clean. It's like giving you an opportunity to rehabilitate in the society. It's not that once a criminal is a criminal forever, once a convict is a convict forever. Then we'll never get people coming back to the society, right? That's how it is. So this is known as spent conviction. However, if the judge feels, this particular offense is so great that that particular conviction should not be considered as spent, that's the judge's discretion that they can do. Coming to the point, so if I have a spent conviction, so to speak, as per Rehabilitation of Offenders Act 1974, then am I a person of good character? Answer: yes. If the judge feels that I have served my sentence, and after serving the sentence, I am a different person and have maintained a clean past for a considerable period of time, I am to be considered as a fresh person, not a person with a mark. But then coming back to the question, if I am then considered to be a person of good character, not because of not having any previous conviction, but because I have conviction, but that can be considered a spent conviction as per the Rehabilitation of Offenders Act 1974, then am I entitled to a good character direction? That's the question. Because as per R versus Y, if I'm a person of good character, then I must get a good character direction. Answer: yes. If I have conviction, but if the judge considers my conviction to be spent, then I am entitled to good character direction as well. Coming to that point, that will lead to some problems. Why? Because generally a good character direction is that this person appears to be a person of good character, doesn't have any previous conviction, and therefore is less likely to have committed the offense, is more likely to be believed. That is how the judge will say. But a person with spent conviction, when the judge is giving a good character direction, can the judge say to the jury that members of the jury, this person appears to be a person of good character because he does not have any previous conviction? Can the judge say that? No. But should the judge say that members of the jury, this person appears to be a person of good character because although he has a previous conviction, but because he has spent 5, 7 years, 10 years clean, therefore he may be considered to be a person of good character? Should he say that? Because if he does say that, he's eventually giving away the fact that I've had a previous conviction and that will actually go against me, right? So he should not say that as well. How should the judge give a good character direction? Again, there is no specific frame. However, there's a guideline. The guideline is this, that the judge should give a direction, and the direction should be somewhat like this. Members of the jury, this person appears to be a person of good character. He does not appear to have any relevant previous conviction. It's just a trick. Members of the jury, this person appears to be a person of good character. He does not appear to have any relevant previous conviction. Therefore, he is more likely to be believed on oath. He is less likely to have committed the offense. However, whether or not he has committed the offense, whether or not he is believable on oath, is for you to decide. Anyway, it's just the direction with a little bit of a twist, and that kind of makes it perfect. Why? The judge is not lying, because the judge cannot lie. The judge is not misleading, the judge cannot mislead. However, at the same time, the judge is giving him the good character direction which he's entitled to, giving him a second chance, giving him a clean slate, if you know what I mean. Clean slate. That's how it is. That's spent conviction. What is spent conviction? Rehabilitation of Offenders Act. Once you have served your conviction, if you have spent considerable time clean, then the judge may decide that you have misconduct conviction. If just judge's discretion. It's like just giving you an opportunity to rehabilitate in the society. Okay, great. Now moving to bad character.
So terminology relevant case.
Relevant previous conviction. It does not appear to have any relevant previous conviction. Okay. You can please write down. Take this dictation. Section 98 of CJ 2003 defines a person's bad character as evidence of misconduct or evidence of a disposition towards misconduct. Evidence of misconduct or evidence of a disposition towards misconduct other than evidence which has to do with the alleged facts of the offense, the alleged facts of the offense with which the defendant is charged, or is evidence of misconduct, or is evidence of misconduct in connection with the investigation or prosecution of that offense. Okay, try and consider this. What is it?
So can you repeat it?
Yeah, I can repeat. As per section 98 of CJ 2003, bad character has been defined as evidence of misconduct or evidence of a disposition towards misconduct, other than evidence which has to do with the alleged facts of the offense with which the defendant is charged, or is evidence of misconduct in connection with the investigation or prosecution of that offense. I give you 30 seconds to read it and explain it. Tell me what you understand. Yes. What is it?
The first part.
Answer. Okay. Let me. We'll talk about it. Article. Section 112, subsection 1. Section 112, subsection 1 defines misconduct as the commission of an offense, as the commission of an offense or other reprehensible behavior, or other reprehensible behavior. Stop. Next paragraph. Reprehensible behavior is treated as something capable of objective assessment. Reprehensible behavior is treated as something capable of objective assessment. Stop. If something is said to be reprehensible, if something is said to be reprehensible, the fundamental idea is that it is blameworthy. In a moral sense. Stop. In short, reprehensible behavior in other words, reprehensible behavior means behavior which ordinary people would generally disapprove. Behavior which ordinary people would generally disapprove. Okay. 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 Now you tell me. Now you read this, the whole thing. Because now I've given you some explanation of some terms of that has been used in the definition, namely misconduct and also reprehensible behavior. Now you read the whole thing and now you try to define it. Give me 30 seconds. Yeah.
So, my confusion lies with the second.
What is bad character? Tell me.
Yeah.
Evidence of misconduct or evidence of disposition toward misconduct? Is this where your confusion is?
No. The confusion is regarding investigation of that offense. You mean the previous offense, right?
On the offense in question? No, it's not the previous offense. The offense in question.
This one.
Yeah. Oh. Okay. Now let me explain. Okay, fine. What is bad character evidence as per section 98? Section 98 defines bad character evidence in a very wide manner, so as to include any evidence of misconduct or any evidence of disposition towards misconduct. Let's take it step by step. Let's take it gradually. Instead of having everything in, let's take it slowly. Repeat. Evidence of misconduct, or Shabin, you can do that later. Evidence of misconduct or evidence of disposition towards misconduct. Now, whatever is misconduct, we'll talk about it later. But let's talk about this. What is disposition towards misconduct? So either if you show some evidence of the deed or evidence of someone towards misconduct, that is evidence of misconduct, he has done a misconduct, you have evidence of that, that's bad character. Or he may not have done a misconduct, but the evidence shows that he has a tendency towards doing a misconduct. That is kind of like preemptive, you know what I mean? It's like, I've done something, that's evidence of that. If I've done something, for example, I've hit you. You have seen that I have done some fighting on the street. Someone has seen it, and fighting on the street, hitting someone amounts to an offense. So evidence of a commission of an offense is evidence of misconduct. But I'm very aggressive. I've shown my aggression at times. I've badmouthed people. I've shown my aggression, but I have not hit anyone. And there is no evidence that I've hit anyone. There is no such, previous incidents where I have hit anyone, but I've always been very, very aggressive and violent in nature. But then, although I haven't hit anyone, but I've been very, very aggressive. You know what I mean? So technically speaking, and I did not really threaten you. So technically, there was not even a technical assault as such. If you say technical assault, there was an offense. But say I did not threaten you, but I showed my aggression. Now that tends to show that I may be violent, because an aggressive person is likely to be violent than not. You know what I mean? So that may be considered as an evidence of not misconduct, but evidence of disposition towards misconduct, if you know what I mean. So that by introducing that alternative in the definition, the Parliament had made it much more wider. So evidence of misconduct is evidence of bad character. Evidence of disposition towards misconduct is also evidence of bad character, right? So that basically takes it much wider, makes it much wider. So it's kind of preemptive. You have evidence of my misconduct, fair enough, that's bad character. You may not have evidence of my misconduct, but you may have evidence which tends to show that I have a tendency, I have a disposition, I have a propensity towards misconduct. Even then, that is also treated as bad character, right? Coming to the point, what is misconduct? Misconduct has been defined as evidence of either commission of an offense or evidence of other reprehensible behavior. Evidence of commission of an offense, what does that mean? Evidence of commission of the offense means evidence that I've done something which amounts to an offense. I've done something which is prohibited by law. With the necessary mens rea, I've done that. So I've actually committed an offense. So evidence of an offense means misconduct has two options. Two ways you can have misconduct. First, commission of an offense. So evidence of my commission of an offense is my evidence of misconduct, or it's even wider. Say you do not have information that I've committed an offense in the past, but you have information that I may have done something which may not necessarily amount to an offense, but may be considered as reprehensible behavior. Coming to the point, what is reprehensible behavior? Well, reprehensible behavior is behavior from an objective perspective, from a reasonable man's point of view, a behavior which falls short of the moral standard expected of the defendant. Are you with me? In other words, reprehensible behavior may not necessarily amount to an offense, because if it was an offense, if it was a defined offense, then it would come in the first category, saying that evidence of offense, right? But then misconduct has been so widely defined that it includes evidence of offense, but it's not limited to that. It goes on further to include reprehensible behavior, and reprehensible behavior means evidence which shows, from a reasonable man's perspective, behavior which any reasonable objective person would not approve of as being immoral or as being less than the moral standard that the reasonable man would expect from you. So for example, what would be a reprehensible behavior? Say I'm a liar. I am a habitual liar. Say if I am. I lie. Is this evidence of my commission of an offense? Is it an offense to lie? It's not. It is not an offense. to lie, unless I'm lying on oath, but thereby I'm committing perjury. But generally, it's not an offense. It's not prohibited by law to lie, right? However, if there is evidence that I'm a liar, I'm a habitual liar, it's just morally acceptable. No. Any reasonable person would he accept this to be okay? No. Would he approve of my such behavior? No. That's reprehensible behavior. I think I'll just give you an example of that. So let's get everything together. Evidence of bad character. What does it mean? Evidence of bad character means, as per Section 98 CJ 2003, evidence of bad character means evidence of me committing an offense, whatever that may be, defined offense, or evidence of me showing disposition towards commission of an offense. Disposition means my tendency, my propensity, my likelihood. My likelihood towards commission of offense. That's propensity. That's disposition. That's one option. Or evidence of reprehensible behavior. So I may not, you may have evidence which may not necessarily show that I've done an offense, defined offense as such, but which may show that I've done something which ordinary people would not generally approve of, morally, as being morally acceptable. Right? That's one. It's even further, it's even wider. Key evidence of disposition towards reprehensible behavior. So you may not actually have evidence of me committing reprehensible behavior, but you may have evidence of me having a disposition towards commission of a reprehensible behavior. So that is that wide, so to speak. Yeah, yeah, right. So that's that character. So section 9. Oh, coming back to the latter part. However, exception. One exception. Pura definition is देखो. Evidence of misconduct or evidence of disposition towards misconduct. Misconduct has been defined as such. Blah blah blah. Yeah. However, except evidence which relates to, let me talk about the other two, which is the exception. Except evidence which relates to the subject matter of the current charge, or any evidence which relates to the investigation or proceeding of the subject matter of the current charge. Basic thing is, so what is that character? Then finally, that character is anything and everything which shows my disposition towards misconduct. Misconduct is defined as either commission of a defined offense or reprehensible behavior. Reprehensible behavior is behavior which ordinary people would not generally accept or approve as being morally acceptable. That's reprehensible behavior. Stand by it. If you have evidence that I have done the offense, if you have evidence that I have the reprehensible behavior, well done, it's that character. If you do not have that evidence, but if you have evidence that I have a disposition or a tendency towards that, মানে এটা কি কারো প্রিএম্পটিভ, তাই না? আমি কাজটা এখনো করি নাই, বাট করার মতো একটা ঝোঁক আছে আমার মধ্যে, right? Then that is also considered as my bad character evidence. So section 9, apart from evidence which relates to the subject matter of the current charge. So if you talk about the subject matter of the current charge, then you can bring in anything and everything. And what is subject matter of the current charge? Subject matter of the current charge means whatever that relates to the allegation at hand. There is a criminal proceeding, right? If the criminal proceeding relates to a particular subject matter, whatever evidence you may have in relation to the subject matter or in relation to the investigation or prosecution of the subject matter or the current allegation that is at hand, that is not considered to be evidence of that character. Even if that shows disposition towards misconduct, that shows misconduct, of course that will show misconduct, but then again it makes sense, right? If this exception was not given in the definition, the problem that you would have faced is that in any trial you would not be able to bring in any evidence. বুঝি কিনা? সাপোজ আমার নামে একটা মামলা করছে যে আমি নাকি ইতিহাসকে মেরেছি, চার থাপ্পড় মেরেছি, এই করেছি সেই করেছি, সেকশন 47 এ মামলা দিয়েছে, মেরেটের একদম ইনজুরি করেছে, হালকা 47 এবিএইচ করেছে। তো এখন আমি ওকে মেরেছি, এটা ভালো কথা, তুমি এখন চাকরি দিতে আসতেছো। আসো, জেনারেল নলেজ কে ব্যাড ক্যারেক্টার এভিডেন্স ইজ নট অ্যাডমিসিবল। So as per section 98, whatever evidence is bad character cannot be admissible. Coming to the point, whenever you want to say যে শাফাত ওকে মেরেছে, কোন একটা উইটনেস বলার চেষ্টা করতেছে, এটা কি এভিডেন্স অফ মিসকন্ডাক্ট না? অফেন্স কমিশন নো সব মিলে যাচ্ছে, রাইট? সো এটাকে যদি আমি ব্যাড ক্যারেক্টার বলে দেই, তাহলে তো এই মামলায় তুমি কোনো এভিডেন্স দিতে পারবে না। যদি কি তুমি কি বলবা, স্টোরিটা তো বলতে পারবে না। সেজন্য ওই এক্সেপশনটা রাখা হয়েছে যে হ্যাঁ, এভিডেন্স অফ misconduct, evidence of disposition toward misconduct. Misconduct has been defined as either commission of an offense or the principal behavior. এগুলো সবগুলোই bad character, এগুলো আনা যাবে না। However, except subject matter of the current charge. তাহলে ঘুরে যদি বলি subject matter of the current charge সম্বন্ধে যা যা আছে নিয়ে আসো, কোনো সমস্যা নেই, কিন্তু subject matter of the current charge বাদে অন্য কোনো misconduct, evidence of misconduct or evidence of disposition towards misconduct আনা যাবে না। Clear? So, in other words, Section 98 gives such a wide definition of bad character, which includes misconduct, disposition towards misconduct, commission of an offense, reprehensible behavior, or disposition towards reprehensible behavior. That wide. Now, final question. Section 98 giving such a wide definition to the term bad character. Is it good or is it bad?
Yeah.
Why bad?
Tendency to আমরা just presume করে নিচ্ছি। It may be মানে এটা
একটা মানুষ মিথ্যা কথা বলে। একটা মানুষ মিথ্যা কথা বলে, right? A person lies. That's a reprehensible behavior. He has not committed an offense. He did not lie on oath, but he lies. He is a habitual liar. That's all I guess. কে ভাই কই দিছ? গেছিলাম একটু বাড়িতে। কোথায় গেলা? এই বললাম। কোথায় গেলা? সুইজারল্যান্ড। শুধু সে আপনার 2 সপ্তাহ ঘরের মধ্যে ঘুমাচ্ছে। সে এটা বলে আছে আমাদের সমাজে এরকম অনেক আমাদের বন্ধু বান্ধবের মধ্যে চেনা পরিচিতের মধ্যে বাবা নাও ইউ অলসো নো আচ্ছা ছিল না ভালো ছিল না হ্যাঁ আচ্ছা ঠিক আছে ভেরি গুড ওয়েল ডান থ্যাংক ইউ ভেরি মাচ বা ছবি দেখলাম না ফেসবুকে না ভাই আমার ক্যামেরাটা নষ্ট হয়ে গেছিল মোবাইল নষ্ট হয়ে গেছিল সামথিং ইউ নো ইউ উইল নট টক অ্যাবাউট ইট ইউ অলসো নো হোয়াট হি সেড নাও দিস আর সামথিং হুইচ ordinary people would generally disapprove but question layman terms যদি চিন্তা করি এটা কি ব্যাড ক্যারেক্টার বলা যায় মানে as per section 98 this evidence is what bad character. But in our layman life, do we consider this to be a bad character? But he's harmless. You know what I mean? So he's a liar, but he's a harmless liar. But he wants to take attention. Right? I'm sure they don't get attention. Because I'm sure they don't get attention from people. As a result, they have to make stories to get the attention. Because everyone craves for attention. That's it. But people who kind of don't get the attention, then they make stories to get the attention. Perhaps. But in a way, we don't necessarily hate them. Yeah, we don't trust them, but then we don't necessarily hate them. You know what I'm saying? They're kind of harmless for the society. But then again, as per Section 98 definition, this evidence is also considered to be a bad character evidence, right? But would we consider this to be bad character in real life? As opposed to evidence of you know what I mean? Violent, a rapist, like a chore, like a burglar, you know. As opposed to all this information, other all bad character. Okay, bad character. But then they looked up for the mitha, right? It took a bad character both. But the mitha are harmless mitha. But it can approve for it, but still bad character. So because of Section 98 is so big, so wide, that event is included within that character definition. Is it good or bad? Yeah. Why bad?
Because it আমরা পড়িনি বা যেটা আমরা
Okay, answer the chief. It's actually good from the perspective of the accused. Why? Because general rule is that character evidence is not admissible in criminal proceeding. So the more wide the definition, the better the protection of the accused. It's actually the other way around. The prosecution will try to, if they want to put in a particular evidence, the prosecution will try to argue that this is not a bad character evidence. Hence, I may be able to put it. But the defense, on the contrary, will argue, no, it's a bad character evidence. You can't put it. বুঝি নাকি? লেভেল টার্মে আমার কাছে মনে হবে যে না প্রসিকিউশন আমাকে ব্যাড ক্যারেক্টার বলার চেষ্টা করবে। আমি নিজেকে ভালো ক্যারেক্টার সচ্চরিত্র বলার চেষ্টা করব, তাই না? But no. It's other way around. Why? Because you are protected. If it's bad character, you don't get it in. You are protected. The more the definition, the more the ambit of bad character evidence, the better your protection. Because less the evidence will be allowed to the jury. Okay? Let's say 1 or 2 cases on this. They go. In case they go, R versus Machado. R versus Machado. In R versus Machado, the D was charged with robbery. He wanted to adduce evidence that evidence that during his encounter with the complainant, the complainant offered to supply drugs to him and told him that the complainant had taken an ecstasy tablet. Ecstasy, ECSTASY, ecstasy tablet.
So the complainant told the defendant.
Yeah, him, and told him that he, the complainant, had taken an ecstasy tablet. The prosecution argued that this evidence should not be admitted.
Is this entrapment?
Yeah. Should not be admitted, as it was evidence of bad character and was excluded by Section 100 of CJA 2003 and was excluded by Section 100 of CJA 2003. The trial judge excluded the evidence of CJA 2003. The trial judge excluded the evidence, but the Court of Appeal held that the evidence related to the very circumstances, in which the offense was alleged to have occurred. Stop. They were therefore matters to do with the alleged facts of the offense, and did not constitute bad character evidence under Section 98. Bad character evidence under Section 98. And, yes, they were therefore matters to do with the alleged facts of the offense and did not constitute bad character evidence under Section 98. Okay? The general rule of bad character evidence is not admissible. But here, the court held that this described the circumstances. You should know. Robbery করেছি ও বলছে রবারি করতে গেলে আমি একটা ফোর্স অ্যাপ্লাই করেছি টেস্ট করেছি এসব কথা ছিল ও বলছে যে নো উল্টাও আমার কাছ থেকে ড্রাগ ডিলিং চাইছিল ও আমার কাছে ড্রাগ দিচ্ছে বা চাচ্ছে এর মতো লেনদেন হচ্ছিল তার মধ্যে আমাদের ভিতরে একটা ডিসপিউট হয়েছে ও বলছে এটা দিছি বা নেই এরকম কিছু তখন ওই প্রশ্নটা আসছে যে হোল্ড অন দিস ইজ মাই ট্রায়াল I am talking about the complainant asking for drugs. I should not be saying that because that is evidence of bad character. Because the defendant was trying to say that the complainant asked for drugs. So the trial judge held that was bad character and that is not admissible. But on appeal, the court of appeal held no, because this evidence, described or explained the whole situation and circumstances of the offense of robbery as per the allegation. The whole story must come through before the jury, and hence it is not to be treated as bad character evidence, and therefore it should be admitted. Because it all happened in the same sequence, right? Your allegation is I committed robbery. My allegation is you said that you wanted drugs from me and you took some drugs. So you say আমার ধারণা যেটা পুরো ফ্যাক্ট আমাদের কাছে নাই, বাট যেটা ধারণা যে তুমি ড্রাগস নিয়ে আমার তোমার সাথে একটা ডিসপিউট হয়েছে, তোমার একটা হাতা দিয়েছে, বাট তুমি কিছু টাকা দিবি না। ড্রাগ ডিলার এরকম হয়, তাই না? কারণ এটা তো লিগ্যাল রেসপন্সিবল না। তো প্রশ্ন হচ্ছে আমি যদি ওখান থেকে তোমার টাকা নিতে চাই, রবারি করি নাই বা রবারি আদৌ করছি কিনা প্রশ্নের বিষয়। কারণ তুমি যদি আমার কাছে ড্রাগ নিয়ে থাকো তাহলে তো আমি তোমার কাছে টাকা, ইউ ও মি মানি, রাইট? এন্ড দেন আমি যদি তখন ওই মানিটা নেই, দ্যাটস আ ডিফারেন্ট স্টোরি অলটুগেদার। হোয়াটএভার, ইস্যুটা হচ্ছে যে ওই দিক থেকে আর্গুমেন্ট হয়েছে যে that should not have been trial judge বলছে that is his bad character evidence complaint non defendant's bad character evidence বলছে না any bad character of a person who is not the defendant is non defendant's bad character evidence non defendant's bad character evidence is dealt with under section 100 of CJ we'll do it inshallah in class and defendant's bad character evidence is dealt with under section 101 of CJ 2003 101 এখানে ক্লাসে দেখব কিন্তু আজকে এটা এখন যেটা দেখলাম এই কেসটা হচ্ছে কি ব্যাড ক্যারেক্টারের অ্যাম্বিটটা রাখা হচ্ছে যে ওটা যদিও এভিডেন্স অফ মিসকন্ডাক্ট কিন্তু যেহেতু ওই এভিডেন্সটা রিলেটস টু দি সাবজেক্ট ম্যাটার অফ দি কারেন্ট চার্জ দ্যাট শুড নট বি ট্রিটেড অ্যাজ এভিডেন্স অফ ব্যাড ক্যারেক্টার ওকে নেক্সট the correct case in R versus Brummett BRUMMIT R versus Brummett The Court of Appeal held that the trial judge had been right. The Court of Appeal held that the trial judge had been right to admit matters that had occurred half an hour or less before the offense was committed. Half an hour or less before the offense was committed. In this case, offense was committed. In this case, the defendant was charged with causing death by dangerous driving. With causing death by dangerous driving. In order to prove that, the prosecution wanted to prove, certain events that had taken place, not more than half an hour earlier, when there had been an altercation, ALTERCATION, half an hour earlier, where there had been an altercation and some violence with a shop manager over a stolen fish tank. Stop. The defendant had driven the van in some haste immediately after the incident. The defendant had driven the van in some haste immediately after the accident. The trial judge ruled all these matters admissible. The trial judge ruled all these matters admissible as evidence that had to do with the alleged facts of the offense. Not as evidence of bad character. Not as evidence of bad character. Stop. The jury was entitled to know. That the defendant had been involved in an emotionally charged incident within half an hour or less of the fatal accident. Of the fatal accident. Stop. It was relevant to his state of mind. It was relevant to his state of mind. And might shed some light. And might shed some light on his manner of driving. On his manner of driving. Stop. Now, this is very interesting. Like, কেন আমার যে কোনো কিছুকে আমার that character বলা হবে না কেন? Yes, if there is evidence of misconduct, evidence of disposition towards misconduct, that's not character. আমি মারামারি করছি, আমি একটা স্টোলেন ফিশ ট্যাঙ্ক নিয়ে কার সাথে রিমার্কেশন হইছে, অল্টারকেশন হইছে, ভায়োলেন্স হইছে, রাগারাগি হইছে, হাতাহাতি হইছে, এগুলো সবই রেফারেন্সিবল বিহেভিয়ার, এগুলো সবই কোনো একটা অফেন্স, রাইট? যদি মারামারি হাতা অ্যাজ ইন ফিজিক্যাল কন্টাক্ট হয়ে থাকে তাহলে অফেন্স হয়ে গেছে, ফিজিক্যাল কন্টাক্ট না হয়ে যদি হয়ে থাকে তাহলে ভায়োলেন্স হইছে বা এরকম কিছু হইছে, এটাকে আমরা রেফারেন্সিবল বিহেভিয়ার বলতে পারি। টেকনিক্যালি স্পিকিং এগুলা ক্যারেক্টার এভিডেন্স হওয়ার কথা ছিল, কিন্তু কোর্ট বলছে, এন্ড কোর্ট অফ আপিল ট্রায়াল কোর্ট বলছে, কোর্ট অফ আপিল এটাকে অ্যাকসেপ্ট করছে যে হ্যাঁ, যেহেতু এটা সাবজেক্ট ম্যাটার অফ দি কারেন্ট চার্জের সাথে সম্পৃক্ত, সেহেতু এগুলো ক্যারেক্টার এভিডেন্স বলা যাবে না। এবং ব্যাখ্যা হিসেবে তারা দিচ্ছে যেহেতু এইখানে মামলাটা হচ্ছে যে whether or not I was driving recklessly, whether or not I was driving dangerously, so my state of mind was also a relevant factor for the jury to consider, and the thing that I did immediately before I started the driving was kind of a relevant factor anyway, and that was also this was related to the investigation or prosecution of the subject of the current charge. Hence, although they were misconduct, although they were evidence of disposition towards misconduct, but they will not be treated as bad character and will be rather accepted as admissible evidence, because they will help the jury to come to a conclusion which is so badly needed. Lost.
Admit ke আমরা প্রুভ করব,
That can
তাহলে এভিডেন্স তো অ্যাডমিট করা যায়
যায় না, এদিকে ব্যাখ্যাটা বলছে নাকি বলে?
এটা ব্যাখ্যা একটু বলুন,
তার মানে কি?
অ্যাডমিট করা যাবে।
হ্যাঁ, তাহলে এই প্রশ্নটা কেন বললা যে অ্যাডমিট করা যাবে কি যাবে না, করবো কি করবো না? করবো, কিন্তু মানে না করার কথা ছিল, তাই না? সেকশন 98 এ তো বলা হয়েছিল যে এভিডেন্স অফ মিসকন্ডাক্ট মানে আসবে না, অ্যাডমিসিবল না, কিন্তু যেহেতু এটা এভিডেন্স অফ দি সাবজেক্ট অফ এভিডেন্স রিলেটিং টু দি সাবজেক্ট অফ দ্য কারেন্ট চার্জ, ইট ইজ টু বি অ্যাডমিসিবল। ঠিক আছে, ওয়ান মোর থিং বলে আজকে শেষ করব, সেটা হচ্ছে
স্যার খালি আপনি লাস্ট লাইনের আগের লাইনটা একবার রিপিট করতে পারবেন কেসটা? The jury was entitled to know that the defendant had been involved in an emotionally charged incident.
Yeah.
Within half an hour or less.
Within half an hour or less. তারপরে কি বলছিলাম?
The fatal accident.
Of the fatal accident, right. Okay. Next case, last case for today would be R versus Z. This answers your question. If you have a question. R versus Z. This relates to acquittals. Whether acquittals are considered as bad character evidence, because yeah, I understand conviction surely is, because it satisfies the requirement. Misconduct money commission of an offense, conviction money proof of my commission of an offense. Acquittal to that. So তাহলে এটা কি হবে? Well, আমি convicted না, কিন্তু আমি কি বলবো, আমার কাছে একটা কমপ্লেইন্ট আসছে, এবং যেই কমপ্লেইনের বিচার হয়েছে, বিচারে আমি সাজা পাই নাই, কারণ প্রসিকিউশন আমার এগেইনস্টে মামলাটাকে বিয়ন্ড রিজনেবল ডাউট প্রমাণ করতে পারে নাই, বাট it does not show proof of commission of an offense. That does it show proof of propensity towards commission of an offense? Firstly, on technical ground, I may not be convicted, but if I was prosecuted for a particular charge, does it show my tendency towards commission of an offense? Number two, it may not be an offense, but is it not reprehensible behavior? Would it not be morally not acceptable by any reasonable member of the society that our name on this? এটাও ঠিক যে reasonable member of the society ভাবতে পারে যে না, ভদ্রলোক সিচুয়েশনের শিকার, তাকে শত্রুতা করে মুখোমুখ কারণে দেওয়া হয়েছে, fair enough. কিন্তু যদি দেখা যায় যে একই ধরনের মামলা আমি বারবার আমাকে মানে একাধিক চার্জ আসছে, it's less likely to be considered as morally acceptable. So the fact that I have been acquitted does not necessarily mean that that evidence is not to be treated as bad character evidence. The fact that I've been acquitted can also be treated as my bad character evidence. That is the summary of the matter. Okay. Do the case R versus Z and R versus Mustafa. MUSTAH. Deals with acquittals. Acquittal যদি এমন হয় যে জাস্ট একটাই আমার নামে অ্যালিগেশন ছিল, সেই অ্যালিগেশন থেকে আমি অ্যাকুইটেড হয়ে গেছিলাম, then it may not be treated as bad character evidence. Especially when the trial did not disclose any substantial evidence anyway. It was all a fake case altogether. Then it may not be a bad character evidence because it may not be even reprehensible behavior. Clear-cut case where I have been somehow framed. But if there is an allegation and I have been tried, although I was acquitted because of lack of beyond reasonable doubt proof, in that case it will be treated as evidence of bad character. Nevertheless, it is a reprehensible behavior because ordinary people would generally not accept too many complaints of similar nature against a particular person. Okay, so let me put it this way: if there is say one particular allegation, and later proven to be fake, and therefore I did not get a conviction. I was acquitted. That particularly one incident may not be treated as an evidence of bad character. But if there is say 2, 3, 4 similar sort of allegation, বুঝে কি বলছিল তোমরা? শাবাত দলটা কেমন? আরে ভাই, হাতে নাতে তো ধরতে পারি না, কিন্তু শাবাত তো বোধহয় খারাপ। তার নামে অভিযোগ আছে। কি অভিযোগ? এই কোন একজন এই ইমতিয়াজ একসময় এটা বলছিল। একটা অভিযোগ, তারপরে ও আর প্রমাণ করতে পারেনি। ও আচ্ছা। Does that mean it's bad character evidence? Does it automatically make it a reprehensible behavior? Not necessarily, because any person can basically bring any allegation against anyone, especially when he failed to prove it. It does not necessarily mean reprehensible behavior. But then when the number of allegations and the similarity of it is more, it tends to be more reprehensible behavior. General people will tend to say, something must be wrong. There is no smoke without fire. Why would so many people have similar allegation against a person if he has not done anything? It does not prove that I've done it, but it surely proves that there is a reprehensible behavior about me. Okay, so that deals with acquittals. We stop here today, and next class we talk about initially non-defendant's bad character, what is the rule, section 100, and then we move on to section 101. Section 101 is the main thrust of the matter for examination, but then section 100 is also necessary. Okay, with that we'll conclude the lecture, but then I would say, I know this technology is there. I really don't know how many people are actually watching or whether they are watching, but our arts of the evidence class will try and attend in person. It cannot be replaced. Okay? This understanding is important. Jani na ki avastha, but tumra spread the word to your friends as well who are appearing for exam this year. Evidence. Jodi keu purikha na seta alada kotha, and jodi keu bare na jete seta alada. Then evidence is not only important for your examination, this final examination, but also is super important for your bar, for your BPTC upcoming. So I really don't see any reason why one must not attend evidence classes just because you have technology. You can see it from. Okay, so you spread the word around. Whenever I will say যে আমরা বৃহস্পতিবারগুলোতে এই ক্লাসগুলো নেওয়ার চেষ্টা করব, এভাবেই we'll try to stick to it. We have lost 2 months of classes. I don't want to lose any more because we really don't have time. We have to finish it. I would like to solve some questions as well once we are done with it. So spread the word and make sure your friends do turn up. Okay, thank you. You do anything here? Stop.